Chapter 11. Preclusive effects of judgments. Key exam issues. After a court has entered judgment, related matters may come up in later litigation involving the same or different parties. For several reasons including economy, prevention of harassment, and avoidance of inconsistent rulings, doctrines of former adjudication sharply limit the extent to which relitigation is permitted. When relitigation is not permitted, parties cannot argue in a new proceeding that the prior ruling was erroneous. The point is taken as established in accord with the prior decision. This field of law has two main components. I claim preclusion, or, in older terminology still in widespread use, res judicata in its narrow sense, which bars reassertion of the same claim, and Roman II issue preclusion in the older terminology, direct or collateral estoppel, which bars relitigation of the same issue, whether it arises in connection with the same claim direct estoppel or a different claim collateral estoppel. 1. Claim preclusion. Key questions are: A. Is the judgment on the same claim? Most jurisdictions now define claim broadly to prevent the bringing of one aspect of a related matter in one action and another aspect in a second proceeding against the same party. Rule against splitting claims. B. Is the judgment final? C. Is it valid? Was it rendered by a court of competent jurisdiction? And was constitutionally adequate notice given? D. Is it on the merits? Did the court rule on the merits of the claim, dismiss with prejudice, or enter a default judgment? E. Did the plaintiff in the prior action prevail? If so, the doctrine of merger precludes a second try. The original claim is merged in the judgment. F. Did the plaintiff lose in the first action? If so, the doctrine of bar precludes the second suit, with the plaintiff's claim regarded as barred by the defeat. 2. Issue preclusion. Key questions are: A. Is the party against whom issue preclusion is sought to be invoked one who was a party to the prior litigation or in privity with such a party? B. Was the issue actually litigated and determined, identical to the issue in the present action, and essential to the prior judgment? C. Can non-mutual estoppel be applied? 1. Are the stakes so much higher in the present case that it would be unfair to apply estoppel? 2. Could the party asserting estoppel easily have joined in the earlier action? 3. Are procedural opportunities available to the party against whom estoppel is asserted in this action that were not available in the earlier action? 4. Have there been inconsistent determinations of the same issue in other cases? A. Introduction. 1. In General 2256, the res judicata doctrine has two components: I claim preclusion and Roman II issue preclusion. 2. Claim preclusion, also called res judicata 2257. A final judgment on a claim or cause of action precludes reassertion of that claim or cause of action in a subsequent suit. A. Merger 2258. If judgment was for the plaintiff on the claim, there is a merger of the claim in the judgment, i.e., the prejudgment claim is transformed into the judgment claim. B. Bar 2259. If judgment was for the defendant, it is a bar against the plaintiffs suing again on the claim. 3. Issue preclusion, also called collateral estoppel 2260. Preclusion prevents not only relitigation of a claim, but also, in some circumstances, relitigation of issues of fact resolved in a prior proceeding, even when the later case involves a different claim. A decision on an issue of fact may be binding in subsequent litigation between the same parties, or, in some circumstances, between one of the parties and a different adversary. 4. Purposes 2261. The purposes of these doctrines are twofold: I. To avoid the time and expense of multiple litigation over the same matter, and Roman II. To give stability to the results of adjudication to prevent inconsistent results. B. Claim preclusion. 1. In General 2262. Before any judgment can have claim preclusive effect, It must be I final, Roman 2, on the merits, and Roman 3 valid. 2. Policy Basis 2263. The basis for claim preclusion is that litigants should be compelled to litigate their entire claim on the first occasion they bring it before the courts. This can serve the following policy objectives. A. Judicial Efficiency 2264. Resolving all claims in a single lawsuit avoids waste of judicial resources on repeated litigation of the same claim. B. Avoiding vexation of defendants 2265. Allowing plaintiffs to sue defendants repeatedly on the same claim by changing their legal theories would raise the risk of oppression of defendants. Defendants should be assured that they will not be forced to answer a given claim more than once. C. Consistency 2266. Although it would often be legally consistent for a plaintiff to lose on one theory and then prevail on another with different elements, requiring litigation of all theories for a claim in a single action promotes the public appearance of consistency. D. Effect foreclosing matters that were never litigated 2267. The net effect of claim preclusion is, therefore, often to foreclose matters that were never litigated because they were never raised in the first litigation. Example: plaintiff sues defendant car salesperson for common law fraud in connection with defendant's sale of a used car to plaintiff. After judgment is entered in this action, plaintiff files a second suit against defendant, this time charging violation of the State Automobile Consumer Protection Act in connection with the sale of the same car. Even though the question of violation of the Act has never been litigated, the second suit is precluded by the first. 1. Distinguish issue preclusion 2268. Estoppel, particularly collateral estoppel, applies preclusion only to matters that were actually litigated and decided in the first lawsuit. 3. Meaning of claim breadth of preclusion 2269. Determining the scope of the claim in the first lawsuit is often difficult. Unless the claim in the second lawsuit is the same, claim preclusion does not apply, although issue preclusion may. A. Traditional tests 2270. The traditional tests were derived from the code pleading concept of the cause of action. The idea was that the first litigation was res judicata only as to the same cause of action. The courts developed tests to give effect to this concept. 1. Same primary right and duty 2271. If the plaintiff asserted a violation of the same basic right in the second case as in the first, preclusion applied. Criticism. Distinguishing between differences in the law that mattered in terms of the elements of the second claim compared to those of the first claim made it hard to determine if the second suit involved the same primary right. 2. Same evidence 2272. If the second claim turned on essentially the same evidence as the first claim, preclusion was said to apply. Criticism. Because there was usually some difference in the evidence that could be presented, this test was also difficult to apply. 3. Mere change of legal theory 2273. If the second suit merely changed the legal theory upon which the earlier suit relied, preclusion applied. Criticism. Although this test accurately portrays one concern of preclusion doctrine, it provides little guidance in determining whether something more than the legal theory has changed. B. Modern Approach Transactional Test 2274. The Restatement Second of Judgments adopts a transactional approach to the scope of claim preclusion. Claim preclusion applies to all or any part of the transaction or series of connected transactions out of which the action arose. Restatement Second of Judgments 241. 1. Flexible Definition 2275. The definition is flexible. What factual grouping constitutes a transaction and what groupings constitute a series are to be determined pragmatically, giving weight to such considerations as whether the facts are related in time, space, origin, or motivation, whether they form a convenient trial unit, and whether their treatment as a unit conforms to the parties' expectations or business understanding or usage. Restatement second of Judgments 242. This analysis requires an examination of the facts underlying the claim similar to that called for in assessing permissive joinder of parties under Federal Rule 20. See Supra, 173 1083. C. Claims by or against different parties, usually not foreclosed 2276. Ordinarily, a claim by one plaintiff is considered a different claim for preclusion purposes from that of another plaintiff, and so is a claim against a different defendant. However, these rules may not apply if the parties are in privity. See infra 23/202331. But closely similar claims can survive a final adjudication. Example: in the first suit, plaintiff sought to recover for his own personal injuries in an auto accident, but lost on a finding that defendant was not negligent. He then brought a second suit as representative for his wife and 3 minor children to recover for their injuries in the accident. He was allowed to pursue these claims because they were not the same as his personal claim. Freeman v. Lester Coggins Trucking, Inc., 771 F2D 865th Sir. 1985. 1. Successor in interest 2020-77. If the first plaintiff's claim is assigned to the second plaintiff, or passes by action of law, the second plaintiff is precluded. Thus, if before death a victim of an accident sues the other driver and recovers for her injuries, the executor of her estate cannot file a second suit against the other driver to recover wrongful death damages for the estate. See infra 2327. 2. Liability of one defendant depends on liability of another 2278. In some situations, one potential defendant may be held to be responsible for the conduct of another. See infra 2336-2337. In such cases, a judgment exonerating one potential defendant precludes an action on the same claim against the other. 4. Final 2279. A ruling at a pretrial hearing, or the determination of an issue severed for trial, does not decide a claim until judgment is rendered. However, if a claim has been separately determined in the course of an action, it may be treated as the equivalent of a final judgment for res judicata purposes, even if the action is still pending. The question for issue preclusion is whether the prior adjudication of an issue in another action is determined to be sufficiently firm to be accorded conclusive effect. The finality requirement is interpreted somewhat more strictly for purposes of merger and bar, since the question then is the creation of a new claim based on the judgment merger or the extinguishment of the claim bar. Restatement second of Judgments 13, Comment G. A. Effective Appeal 2280. Whether a judgment on appeal is final for purposes of res judicata is determined by the law of the jurisdiction in which the judgment was rendered. 1. Federal Practice 2281. In federal practice, once a judgment is entered, it is deemed to be final, even though an appeal therefrom is pending. The judgment remains final and valid until reversed or modified by the appellate court. In such jurisdictions, preclusion attaches immediately upon entry of the judgment. United States v. Nisco Laboratories, Inc., 318 F2D 817 2D Sir. 1963. A. Note. As a practical matter, however, any suit to enforce the judgment, or in which the res judicata issue is otherwise involved, is likely to be abated or continued until the pending appeal is determined. B. And note. Even courts that have somewhat expanded the notion of finality for preclusion purposes may look to whether there was an opportunity for appellate review. A partial summary judgment followed by a settlement that prevents appellate review, for example, will ordinarily not be given preclusive effect. American Casualty Corp. v. Century Federal Savings Bank, 867 F. Sup. 50D. Mass. 1994. 2. State Practice 2282. In many states, the taking of an appeal automatically postpones finality until the appeal is determined. Until then, no res judicata attaches. Sosa v. DirecTV, Inc., 437 F3D 9 and 23 9 Sir. 26. Applying California law. B. Modifiable judgments 2283. Many civil judgments are non-final in the sense that they are subject to modification, e.g., alimony awards, child custody determination, and some kinds of injunctions. Such judgments do not prevent reconsideration of the relief granted, for example, when conditions have changed, but they are res judicata until modified. Restatement second of Judgments 13, comment C. C. Conflicting judgments 2284. If two judgments are in conflict, usually the last in time controls. Restatement second of Judgments 15. Example. If a judgment is rendered in Action 1, but is not raised or established in Action 2, or the court in the second action holds that the earlier judgment is not entitled to res judicata, and both judgments are otherwise final, the second judgment is controlling. Hence, it rather than the earlier judgment is entitled to res judicata in any third proceeding on the same claim. Trainees v. Sunshine Mining Co., 308. U.S. 66, 1939. 5. On the merits. A. General Rule 2285. A judgment is deemed to be on the merits if the claim has been tried and determined, i.e., if the court has ruled that the plaintiff has or has not established his claim. This includes a determination by summary judgment, judgment on the pleadings, non-suit, and directed verdict, as well as a determination after trial and verdict. 1. Note. Rulings not on the merits generally are preclusive only as to issues. If the court dismisses on a ground that does not relate to the merits, e.g., for lack of jurisdiction, improper venue, or a dismissal expressly without prejudice to a new action, the judgment or dismissal usually does not bar a subsequent action. Restatement second of Judgments 20. 2. But note. Such a judgment is determinative of issues decided. Example. A dismissal for improper venue, because the defendant is not a resident of the county where sued, is determinative of that issue in a subsequent suit, see infra 2302 et sec. When the second suit is on the same claim. This relatively uncommon form of issue preclusion is known as direct estoppel. B. Meaning of on the merits 2286. If an action is dismissed on a ground closely related to the merits, the following approaches apply. 1. Dismissals 2287. If dismissal is for failure to state a claim, but it is possible that the complaint could be amended to state a valid claim, or if there was a dismissal for failure to diligently prosecute the action. Earlier cases held that the judgment was not on the merits and hence not a bar. A. But note. Today, such a dismissal is considered a bar on the theory that the plaintiff had a fair opportunity to get to the merits by amending his pleading, appealing, etc. Reinhardt v. Locke, 454 F2D 313 7th Sir. 1971. 2. Default and consent judgments 2288. Default and consent judgments terminate the cause of action and hence have claim preclusion effect, i.e., result in merger or bar of the claim. Note, however, that a default judgment may be less effective in regard to issue preclusion. See infra 2307. 3. Punitive dismissals 2289. A punitive dismissal is a dismissal based on a party's refusal to obey trial court orders, e.g., a dismissal of a plaintiff's action for failure to prosecute diligently, or a default judgment against a defendant for refusal to obey a discovery order. Because such judgments terminate the cause of action, they have claim preclusion effect, but they do not involve issue preclusion regarding issues going to the merits. 6. Valid 2290. The third requirement for claim preclusion is that the judgment be valid. A judgment is valid unless I. The court lacked subject matter jurisdiction of the case, see supra. Chapter Roman 2. Roman 2. The notice given to the defendant failed to conform to due process requirements, or substantially departed from the requirements of statute or court rule concerning the form of notice C supra 224 et sec. Or Roman 3. The court lacked personal jurisdiction over the defendant C supra. Chapter I. A. Determination of validity 2291. If the question of validity was litigated in the original action, that determination is itself res judicata. Baldwin v. Iowa State Traveling Men's Association, 283 U.S. 522-1931. This is an example of direct estoppel C supra, 2285. Example: a court exercises jurisdiction in an action concerning land on the basis that the land is within the state, rejecting defendant's contention that the land is across the state boundary and hence in another state. This determination of jurisdiction is conclusive, and the judgment may not thereafter be attacked as invalid. Durfee v. Duke, 375 U.S. 106 1963. 1. And note: res judicata also applies to decisions concerning the court's subject matter jurisdiction. Stoll v. Gottlieb, 305 U.S. 165 1938, and the adequacy of notice. Gordon v. Gordon, 227 SE2D 53 Gay, 1976. 7. Claim preclusion when jurisdiction is in rem or quasi in rem. A. Definition 2292. Jurisdiction in rem or quasi in rem is based on the presence of the property about which the lawsuit is concerned. C supra 61. For example, a state can exercise jurisdiction to determine rights under a mortgage pertaining to land in that state. B. Res judicata effect 2293. If jurisdiction is exercised in rem or quasi in rem, the rules of claim and issue preclusion apply essentially as they do in personam judgments, except that the preclusion is limited to claims in the property. 1. Claim preclusion 2294. Suppose Anne brings a suit to foreclose a mortgage on property in State X, serving notice in State X on Beth, the mortgagor. A judgment for or against Anne is res judicata as to her claim to foreclose. However, if no jurisdiction was exercised to determine Beth's in personam indebtedness to Anne, that claim is not determined and still may be sued upon by Anne. 2. Issue preclusion 2295. Any issues determined in the in rem proceeding, e.g., the enforceability of the mortgage note, are conclusive in subsequent litigation. 8. Attachment jurisdiction 2296. Attachment jurisdiction is exercised by seizing local property as a basis for collecting on an obligation allegedly due from its owner, the obligation being unrelated to the property. A. Res judicata effect. 1. Claim preclusion 2297. A judgment based on attachment jurisdiction does not extinguish the claim, except to the extent of the property seized. 2. Issue preclusion 2298. However, the issues actually litigated are conclusive on the parties, if the amount of the property attached was large enough to give them a fair incentive to litigate. B. Restriction 2299. Attachment jurisdiction has been considerably restricted by Schaefer v. Heitner, Supra 77, but it has not been eliminated. 9. Exceptions to claim preclusion 2300. Only under extraordinary circumstances may a party relitigate a claim that has been reduced to judgment. The losing party would have to establish grounds for setting aside the judgment, e.g., fraud on the court, and that she has a good case on the merits. The policy is very strongly against relitigation. See Supra 2262-2267. Example: 7 consumers brought actions under the federal antitrust laws charging defendant department stores with conspiring to fix prices of women's clothing. The actions were dismissed on the ground that consumers had no standing to sue for price fixing. 5 of the plaintiffs appealed, and the other 2 filed new actions asserting claims under state antitrust law. The Supreme Court then held that consumers did have standing to sue. and the judgments against the 5 plaintiffs who appealed were reversed and remanded for further proceedings. In these circumstances, the Ninth Circuit created an exception to res judicata so that the other 2 plaintiffs could proceed with their actions. The Supreme Court reversed, stressing that res judicata serves the vital interest that there be an end to litigation. Federated Department Stores, Inc. v. Moiety, 452 U.S. 394 1981. 10. Defenses and Counterclaims. A. Effect of Compulsory Counterclaim Rules 2301. A compulsory counterclaim rule or statute requires that the defendant set up any counterclaim she has against the plaintiff arising out of the same transaction as the plaintiff's claim. Fed. R. Civ. P. 13a. If she fails to do so, she is barred from thereafter asserting the counterclaim, either as a defense or as the basis for affirmative relief in an independent action. Hence, the judgment in the former action is preclusive as to claims that were or should have been asserted as compulsory counterclaims in that action. Baker v. Gold Seal Liquors, Inc., 417 U.S. 467 1974. B. Where no compulsory counterclaim rule involved 2302. If no compulsory counterclaim rule or statute applies, claim preclusion does not prevent the defendant from asserting the same matter first as a defense to the plaintiff's action, and later in a separate suit as a basis for independent relief against the former plaintiff. Example: contractor sues owner for money due under a construction contract. Owner successfully defends by showing that the work was not properly done, but no counterclaim is asserted. Owner may subsequently file an independent damage action for the improper work, assuming no compulsory counterclaim statute is in effect. 1. But note: because of issue preclusion below, the issues actually litigated and decided in the first action may not be relitigated. 2. Exception: nullifying initial judgment 2303. If a former defendant seeks relief in a later suit based on a claim that could have been asserted as a counterclaim, and the relief sought would nullify the judgment entered in the earlier suit, the later action is barred, even if there was no applicable compulsory counterclaim rule in the earlier action. Restatement second of judgments 221b. Example: in the first action, McDonald's sued in a state court without a compulsory counterclaim rule to terminate its franchise agreement with plaintiff under a provision forbidding any member of plaintiff's family to acquire an interest in a competing fast food business. Plaintiff's son had bought a Burger Chef franchise in a nearby town. After judgment was entered in the first action finding a breach of the franchise agreement and directing sale of the franchise, plaintiff sued McDonald's, alleging that application of the non-competition provision of the franchise agreement violated the antitrust laws. The court held the second action foreclosed because its prosecution would nullify rights established by the prior action. Martino v. McDonald's Systems, Inc., 598 F2D 1979 7 Sir. 1979. C. Issue preclusion. 1. Direct estoppel 2304. Issues actually litigated between the parties are binding on them in subsequent actions concerning the same claim. Example: in a child support suit in which several modification proceedings have been held, issues actually litigated and determined in an earlier proceeding, e.g., legitimacy of the child, are binding on the parties in subsequent proceedings. 2. Collateral estoppel 2305. If the second lawsuit involves a different claim and hence no merger, bar, or direct estoppel, the first judgment may be invoked as to all matters actually litigated and determined in the first action and essential to the judgment. Cromwell v. County of Sac, 94 U.S. 351 1976. Restatement second of judgments 27. Example: plaintiff sues defendant to collect interest that has become due on a promissory note. Defendant defends on the ground that she was induced by fraud to sign the note, and wins. If plaintiff later sues to collect the principal amount of the note after it matures, the prior determination on the question of fraud is conclusive against him. A. Actually litigated 2306. The issue preclusive effect of a prior judgment applies to issues actually litigated in the former action, but not to those that merely could have been litigated therein. Example: landlord sues and recovers judgment against tenant for rent owed. Later, landlord sues again for additional rent owed under the same lease. Tenant now interposes the defense that the lease was invalid at all times. The earlier judgment is not collateral estoppel as to this issue, since the only thing litigated in the first action was the rental claim, and the court was not called upon to determine the validity of the lease. 1. Default Judgments 2307. There is a split of authority on whether a default judgment creates issue preclusion. A. Conclusive 2308. Many decisions hold that a default judgment is conclusive as to all issues that were necessarily involved in the former suit, even though the action went by default and there was no actual litigation thereof. Norix Petroleum Limited v. Access Industries, Inc., 416 F3D 146 2D Sir. 2005. B. Not conclusive 2309. However, there is substantial authority contra, including Restatement Second of Judgments, holding that actually litigated requires evidence presented to, and a decision by, a trier of fact so that default judgments do not qualify. Restatement Second of Judgments 27, Comment E. 1. Rationale. This is believed to be the better view, because a person defaulting to a complaint may not have foreseen that the admissions created thereby would return to haunt him in a subsequent, unrelated lawsuit. 2. Stipulated Judgments 2310. There is likewise a split of authority on whether a stipulated consent judgment is issue preclusive. A. Comment. Even if an issue conceded through a default or consent judgment is not treated as within the rule of issue preclusion, it will be admissible under the law of evidence as an admission. See Evidence Summary. 3. Jury vs. Non-jury trial 2311. The presence or absence of a jury in the first trial is a neutral factor, i.e., matters actually litigated in Action 1 may be held collaterally estopped in Action 2, even if there was no right to a jury in the earlier action, e.g., a suit in equity, and the present suit is jury triable, e.g., action for damages. Park Lane Hosiery Co. v. Shore, 439 U.S. 322 1979. B. Essential to First Judgment 2312. Collateral estoppel applies only to those matters decided in the earlier lawsuit that were essential to the court's determination, i.e., essential to the cause of action or defense established by the judgment therein. Other matters involved in the earlier lawsuit, even though actually litigated, are not binding in a later action. Restatement Second of Judgments 27. Example: plaintiff sues defendant over personal injuries sustained in an auto accident. The court finds that I plaintiff was contributorily negligent, and Roman II defendant was also negligent. The finding that defendant was negligent may not have been necessary. It would be immaterial if plaintiff's claim is barred by his own contributory negligence. Consequently, when defendant later sues plaintiff for his injuries and the same accident, the finding in the earlier action that defendant was negligent is not binding against defendant. 1. Test 2313. An issue is essential to the court's determination in the former action only if it appears that the judgment could not have been reached without determining the issue. Mansoldo v. State, 898 A2D 1018 NJ, 2006. 2. Alternative Findings 2314. There is a split of authority on whether alternative findings, either of which would have been sufficient to support the judgment, should create estoppel in other proceedings. Compare Halpern v. Schwartz, 426 F2D 102 2D Sir. 1970, and Restatement Second of Judgments 27. Comment I know estoppel. Within Re Westgate, California Corp. 642 F2D 174 9th Sir. 1981 estoppel allowed. Example: in an action to declare involuntary bankruptcy, debtor was found to have committed 3 acts of bankruptcy misconduct, each of which would be sufficient to support the determination that involuntary bankruptcy was proper. In a subsequent action concerning her discharge, estoppel was asserted on the basis of one of the 3 findings because it involved fraud. The court held that estoppel should not apply because the finding was merely an alternative basis for the decision. Halpern v. Schwartz, Supra. A. Significance of Appeal 2315. Some courts distinguish between cases in which the earlier judgment was appealed and those in which it was not. If no appeal was taken, they will hold that neither finding is preclusive. If an appeal is taken, however, there is preclusion with respect to those issues that the appellate court reaches that support its judgment. Restatement 2nd of Judgments 27, Comment O. 3. Ultimate vs. Evidentiary Facts 2316. Some cases have held that the previous determination of an issue is conclusive when the ultimate facts in the 2 actions are the same, but not when the first finding is simply a step, i.e., a mediate or evidentiary fact, toward the ultimate fact in the second action. Evergreens v. Nunnan, 141 F2D 927 2D Sir. 1944. Example: in a personal injury action, a finding that defendant was negligent would clearly be an ultimate fact, whereas a specific finding that defendant had failed to maintain or repair her vehicle in a safe condition might be treated as evidentiary. A. Modern approach contrary 2317. This distinction generally is not accepted. See Synonym Church v. United States, 820 F2D 421 DC, Sir. 1987. Issue preclusion applies to any fact determination actually litigated and essential to the judgment, without any distinction between ultimate and mediate or evidentiary facts. C. Identical issue 2318. The issue decided in the prior adjudication must be identical to the one presented in the instant action. Mere similarity of issues is not enough. Example: when the first suit involved an alleged breach of contract by defendant, there was no collateral estoppel in a second action involving Securities Act violations because the issues were different, even though the same conduct by defendant was involved in both actions. Watson v. Roberts, Scott & Co., 466 F2D 1E 348 9th Sir. 1972. Example: in the first action, the court held that a worker could recover for injuries from defendant manufacturer of asbestos. This decision did not provide the basis for estoppel against the manufacturer in a later action brought by another worker, because issues raised in the later action were not identical and depended on the actual and different circumstances under which the later plaintiff was exposed to asbestos products. Hardy v. Johns Manville Sales Corp., 681 F2D 334 5th Sir. 1982. D. Exceptions 2319. Issue preclusion is not as strictly applied as claim preclusion. 1. When the 2 actions involve the same parties. Under Restatement 2nd of Judgments Section 28, the loser may be allowed to relitigate an issue in a subsequent action if, for example, a. as a matter of law, appellate review of the initial action was unavailable. Kircher v. Putnam Funds Trust, 126 S. CT. 2145 2006. B. Even if review was available, the nature of the proceedings in the court handling the first action was informal or expedited, as in a small claims court. C. The stakes involved in the second suit are much larger, as when the first action was in small claims court and the second involves a major personal injury claim. D. The issue is one of law, and the claims in the 2 actions are substantially unrelated. American Casualty Co. v. Century Federal Savings Bank, 867. F. Sup. 50D. Mass. 1994. E. He burden of proof is materially different or has shifted, or F. There is a clear and convincing need for a new determination. Because, for instance, the party who lost on the issue could not have been expected to foresee that the issue would arise in a later action. 2. When the second action involves a different party. All these exceptions apply, and, in addition, the loser may relitigate if there are other factors that justify allowing her to do so. See Infra 2341. D. Persons precluded by judgments. 1. Parties and privies 2320. Judgments may have a preclusive effect on parties, and those in privity with a party. A. Parties 2321. A party to a judgment is bound by claim preclusion, so that she cannot relitigate the claim and issue preclusion, so that, ordinarily, she cannot relitigate an issue determined in the first action. B. Privies 2322. A person in privity with a party is usually bound to the same extent as the party. Privity is a legal conclusion, indicating that the person in question has a relationship to the party such that he should be bound. Whether privity exists depends in part on the type of claims involved. There are two general categories of privity. 1. Procedural privity 2323. If the party acted in the first action as the representative of the non-party, the judgment therein binds the non-party. Restatement second of Judgments 41. Examples. A party appearing as the representative of a class in a class suit King v. International Union, 114 Cal. App. 2D 159 1952. A trustee or guardian representing a beneficiary or ward Armstrong v. Armstrong, 15 Cal. 3D 942 1976 parent for child. Or a party whose interests are represented by an executor or administrator. 2. Substantive privity 2324. Privity may also arise out of substantive legal relationships, with the non-party bound because of a prior legal relationship to the party. Restatement second of Judgments 41 examples include the following. A. Bailment 2325. Either the bailee or the bailer can sue a third party for injury to the bailed chattel, and an action by one precludes an action by the other. Anheuser-Busch, Inc. v. Starley, 28 Cal. 2D 347 1946. B. Medical losses of child or spouse 23-26. In most states, medical expenses e.g. hospital bills paid by a parent or spouse can be recovered either by the injured person or by the parent or spouse who paid them. Hence, an action by one of those who could recover the expenses precludes an action by any of the others. Restatement second of Judgments 48. C. Successor in interest 23 or 27. A successor in interest to property is bound by a judgment regarding that interest to which his predecessor was a party. Kartheiser v. Superior Court, 174 Cal. App. 2D 617 1959. Example. Plaintiff sues defendant, an adjoining landowner, to determine the boundary between the properties. After judgment, plaintiff transfers the property to third party. Third party is bound by the prior determination of the boundary. D. Beneficiary of estate 2328. A beneficiary of an estate is bound by an action litigated on behalf of the estate by the trustee. Restatement second of Judgments 41a. E. Public official authorized by law to act on person's behalf 2329. If a public official is authorized by law to act on a person's behalf, the person is bound by the official's litigation on his behalf. Restatement second of Judgments 41d. F. Virtual representation 2330. In unusual circumstances, courts may say that even if there is no formal representational role, an earlier litigant was the virtual representative of the later litigant, and the later litigant is therefore bound. This doctrine is narrowly interpreted and available only in special circumstances. Tice v. American Airlines, Inc., 162 F3D 966 7th Sir. 1998 criticizing virtual representation as a catchy phrase that has cast more shadows than light on the problem to be decided, but recognizing that it may have validity in some public law cases. Example: when a city had sued an airline to prevent it from using a certain airport in violation of a city ordinance and lost. Other airlines could not file a second suit relying on the ordinance because private parties may not seek to enforce an ordinance after the governmental body that enacted the ordinance has tried unsuccessfully to enforce it. Southwest Airlines Co. v. Texas International Airlines, 546 F2D 84 5th Sir. 1977. Compare. The outcome in an antitrust suit brought by one company was not binding on another company making identical claims, even though both companies had the same lawyer. And the president of the second company participated in strategy sessions before the trial of the first company's suit and voluntarily appeared as a witness for the first company at the trial of its case. Benson and Ford, Inc. v. Wanda Petroleum Co. 833 F2D 1T172 5th Sir. 1985. 3. Distinguish family relationships 2331. The fact that parties have a legal relationship with each other does not of itself make them privies. Thus, a husband's lawsuit is not binding on his wife, unless, in a community property state, the husband represents the community in maintaining the suit. Neither does a parent necessarily represent a child. Whether privity exists depends on whether there is a representative capacity arising out of the relationship. Example: in a divorce action with wife, husband litigated the question of whether he had given half ownership of the family farm to his sons. The sons were not bound by the result, even though they testified as witnesses in the divorce action. Cyril Brothers v. Cyril, 588 P2D 689 Utah 1978. Example: parent and child are both hurt in an automobile accident with defendant. If parent sues defendant for his injuries and loses, that does not bar child from suing defendant for child's injuries. Compare. If parent sues as child's guardian for child's injuries, that precludes a suit by child because she was represented in the first suit. See Supra. 23-26. Although it would not preclude a suit by parent for his own injuries, because that is a different claim. See Supra. 22-76. 2. Non-parties. A. Non-party not bound 2332. In general, a non-party is not bound by judgment. Such a person has not had his day in court, and, as a matter of due process, he cannot be denied a valuable interest, his right of action, without one. Park Lane Hosiery Co. v. Shore, Supra. 2311. Instances of privity above are exceptions to the rule, justified on the ground that the non-party's interests were adequately represented by the party to the first action. Example: no binding effect on non-parties. White firefighters, who had not been parties to a prior litigation between a city and civil rights claimants that resulted in consent decrees establishing minority hiring and promotion goals, were not precluded from bringing a discrimination suit against the city. It was immaterial whether the white firefighters could have intervened in the first litigation. The burden of joining additional parties to secure binding effect against them is on those already parties. Martin v. Wilkes, Supra. 11112. 1. Federal Statutory Exception 2333. For cases involving federal employment discrimination claims, Congress, in the Civil Rights Act of 1991, changed the ruling of Martin, Supra, to give binding effect to a litigated or consent judgment or order when the non-party had adequate notice and opportunity to present objections, or when the non-party's specific interests had been adequately represented by another. 42 U.S.C. 20E2N. 2. Due process limits on extreme application of state preclusion law 2334. Although states are generally free to decide the content of their own preclusion law, federal due process principles impose some limits on extreme applications to non-parties. Postal Telegraph Cable Co. v. City of Newport, 247 U.S. 464 1918. Thus, Individual taxpayers who sought to challenge a county occupation tax levied upon them could not be bound by a prior, unsuccessful non-class action brought by a city against the county challenging the same tax. When the taxpayers received no notice of the first action, and the court and parties had done nothing to assure adequate protection of their interests. Richards v. Jefferson County, 517 U.S., 793 1996. South Central Bell Telephone Co. v. Alabama, 526 U.S., 160 1999. Compare Hansberry v. Lee, Supra, 11210. B. Non-party may benefit 2335. A non-party may benefit from the judgment in an action to which he was not a party. 1. Claim preclusion 2336. In a number of situations, two potential defendants will have a relationship such that one is responsible for the conduct of the other. Examples include employer and employee under the principle of respondent superior and insurer the insurer being liable, up to the policy limits, for acts of the insured. When this relationship of vicarious responsibility exists, a judgment exonerating either potential defendant precludes an action on the same claim against the other. Example: plaintiff claims injuries as the result of negligence by employee who was acting in the course and scope of his employment for employer. If plaintiff sues either employee or employer alone, a judgment exonerating that defendant on a finding of no negligence by employee will preclude a claim against the other, since employer's liability is derivative in nature. A. Not applicable to joint or concurrent liability 2337. This form of claim preclusion applies only in situations of vicarious responsibility, and not in cases of joint or concurrent tort liability. Thus, if plaintiff is injured by the concurrent negligence of driver and owner, each of whom operates his own car, and plaintiff sues driver and loses, that judgment does not bar plaintiff from suing owner. But if driver was driving owner's car, and plaintiff lost in an action against driver, plaintiff could not sue owner based on driver's conduct. 2. Issue preclusion. A. Basic Rule 2338. A party who litigates an issue against one party and loses may not relitigate that issue with another party. Example: driver and passenger are injured when driver's car is hit by defendant's car. Driver sues defendant, contending that defendant was negligent, and wins. If passenger then sues defendant, defendant is bound by the first action and cannot relitigate whether he was negligent. 1. Rationale. If a party has had a full and fair opportunity to litigate an issue in one action, there is no reason to waste the time of the court and other persons in relitigating that issue. Blonder Tongue Laboratories, Inc. v. University of Illinois Foundation, 402 U.S., 3-13, 1971. Bernhard v. Bank of America, 19 Cal. 2D 807 1942. The rule is often referred to as the Bernhard Rule. B. Background Mutuality Rule 2339. Before Bernhard, Supra, the mutuality rule prevented a non-party from having the benefit of issue preclusion in his favor. The theory was that an estoppel should apply only if it was mutual, i.e., since the non-party would not have been bound by the issue had it been decided the other way, because he had not had his day in court. He should not be able to invoke estoppel in his favor based on the earlier judgment. Bernhard, which rejected this mutuality rule, is now the majority view. Restatement 2nd of Judgments 29. C. Offensive vs. Defensive use of prior judgment 2340. Earlier decisions held that issue preclusion could be used defensively against a plaintiff, but not offensively against a defendant to block defendant's attempt to relitigate issues on which he had lost in the earlier trial. However, the Supreme Court has held that this is not a critical distinction. Park Lane Hosiery Co. v. Shore, Supra, 2332. Example: defensive use. Plaintiff claims to have been injured by the concurrent acts of Defendant 1 and Defendant 2. In an action by plaintiff against Defendant 1, it is found that plaintiff suffered no actual injury. If plaintiff later sues Defendant 2 for the same loss, Defendant 2 can invoke issue preclusion defensively. Ponce v. Tractor Supply Co. 29 Cal. App. 3D 500 1972. Example offensive use. Passenger 1 and Passenger 2, passengers in a bus, are hurt when the bus collides with a train. Passenger 1 wins in his suit against the railroad. Most decisions would permit Passenger 2 to use the earlier judgment as conclusive proof against the railroad in a suit by Passenger 2. Example offensive use. In Action 1, the SEC files suit against corporation for false statements in a proxy solicitation in connection with a proposed merger, i.e., mailings to the shareholders seeking their votes to approve the merger. Judgment is rendered against corporation. In Action 2, shareholders file suit against corporation seeking damages as a result of their reliance on the same proxy solicitation. The judgment rendered against corporation in the SEC action may be held to bar corporation from relitigating the issue of whether the solicitation was false and misleading. See Park Lane Hosiery Co. v. Shore, Supra. D. Limitations 2341. Although issue preclusion can be used offensively or defensively, the benefits of such estoppel may be denied under certain circumstances. 1. Issue would not be conclusive between parties 2342. If the issue would not be treated as conclusive between the parties to the first action, see Supra. 23-19. It cannot be conclusive in favor of a third person, not a party to the first action. Example. Plaintiff is slightly injured while a passenger in driver 1's car when it collides with driver 2's car. Plaintiff sues driver 1 for $300 in doctor's bills and wins on a finding that driver 1 was negligent. Driver 2 then sues driver 1 for $250,000 in personal injuries. The finding in the first action does not preclude driver 1 from litigating the question of negligence against driver 2, because the amount involved in the first case was so small that it would not be treated as conclusive even between plaintiff and driver 1 in a second action. 2. Unjust under circumstances 2343. In addition, a third person cannot have the benefit of issue preclusion against a party to the first action if it would be unjust in the circumstances. In deciding whether preclusion would be unjust, the court may consider relevant factors such as the following. See Restatement Second of Judgments 29. A. Whether the person seeking the benefit of preclusion could have joined in the prior action, but decided instead to sit it out. B. Whether the prior determination was itself inconsistent with an earlier determination of the same issue. C. Whether the consequences in the second action are much more serious than those in the first action. Cochran v. Union Lumber Co. 26 Cal. App. 3D 423 1972. D. Whether the party to be estopped has procedural opportunities in the second action, e.g., broader discovery, ability to compel live testimony of important witnesses that were not available in the earlier action. E. Whether the prior finding was apparently a compromise verdict. F. Whether the issue is one of law whose reconsideration should not be foreclosed. United States v. Mendoza, 464 U.S. 154 1984. Federal government, not subject to issue preclusion from prior determination in litigation with different party. And G. Whether other compelling circumstances justify relitigation. E. Interjurisdictional preclusive effects of judgments. 1. Introduction 2344. In the United States, there are 50 state court systems as well as the federal court system. Although preclusion issues often arise when the later case is in the same court system as the earlier case, it also happens frequently that the second case is in a different court system. When that occurs, the attitudes toward preclusion of the first court system and the second court system may differ, and a decision will have to be made about which principles to apply. 2. Basic Rule 2345. The basic rule regarding interjurisdictional preclusive effects of judgments is that the preclusion principles of the court system that rendered the judgment should be used to determine its preclusive effect. A. State court judgments constitutionally entitled to effect in other state courts, 23 and 46. Under the Full Faith and Credit Clause, Article Roman 4, Section 1 of the Federal Constitution, full faith and credit shall be given in each state to the judicial proceedings of every other state. B. State court judgments given effect in federal and state court by Statute 23 and 47. The Full Faith and Credit Statute, 28 U.S.C., Section 1738, directs that state court judgments shall have the same full faith and credit in every court within the United States and its territories and possessions as they have by law or usage in the courts of such state, territory, or possession from which they are taken. This statute requires federal courts and courts of other states to give effect to state court judgments, and also directs that the preclusion principles of the rendering jurisdiction be applied. Example: plaintiffs filed suit in an Illinois state court, alleging a violation of a common law right of association resulting from denial of their applications to join a professional group. Their suit was dismissed and plaintiffs thereafter sued in federal court, asserting that there had been a federal antitrust violation. The state court could not have entertained the federal antitrust claim because it was subject to exclusive federal jurisdiction. The federal district court, nevertheless, did not inquire about whether claim preclusion would apply under Illinois preclusion law, and instead dismissed based on general preclusion principles. This was error because Section 1738 requires the federal court to look to state preclusion law. Marys v. American Academy of Orthopedic Surgeons, 470 U.S., 373 1985. Example: even though federal common law of preclusion permitted relitigation if an earlier case ended in default judgment, a California state court judgment was binding in a subsequent federal bankruptcy court proceeding because California law treated default judgments as binding. Bay Area Factors v. Calvert, 105 F3D 315 9th Sir. 1997. 1. Caution. In practice, some state courts seem unaware of the obligation to follow the preclusion law that would govern in the courts of the system that rendered a judgment, and they may apply their own preclusion principles instead. Because preclusion doctrines are often similar in different systems, however, such ignorance of the proper source of applicable preclusion law will usually make no practical difference. C. Federal court judgment generally given effect according to federal principles of preclusion 2348. Even though there is no explicit constitutional or statutory provision to this effect, it is accepted that federal court judgments are entitled to preclusive effect, and that this effect is determined according to the federal common law of preclusion. Stoll v. Gottlieb, 305 U.S. 165 1938 judgment of a federal court in a federal question case entitled to preclusive effect as determined by federal common law of preclusion. 1. Diversity cases 2349. Federal common law governs the preclusive effect of federal courts' judgments in diversity cases. But because state substantive law is at issue, no uniform federal rule is needed. Hence, absent a federal interest such as enforcement of sanctions for discovery misconduct, the federal common law governing the preclusive effect of a federal court's diversity judgment is the law that would be followed by the courts of the state in which the federal diversity court sits. Semtech International Inc. v. Lockheed Martin Corp. Supra, 589. D. Scope of effect of first judgment, 2350. Although the preclusive effect of a judgment is determined in the first instance by the preclusion law of the state that entered it, that effect cannot exceed the scope of what the judgment could legitimately conclude, e.g., it could not bind persons not parties to the judgment. Baker v. General Motors Corp., 522 U.S., 222 1998 Michigan State Court injunction that prohibited witness from testifying without GM's permission in later cases in which GM was a party did not preclude subpoenaed testimony of that witness in suit against GM by unrelated plaintiff in federal court in another state. 3. Prohibition against giving broader preclusive effect than required 2351. Ensuring that judgments of sister states are given due respect might seem to permit giving them more effect than would the courts of the state where the judgment was rendered. Nonetheless, the Supreme Court has interpreted the full faith and credit statute to forbid a federal court to give more effect to a state court judgment than is called for by the preclusion rules of that state. Marys v. American Academy of Orthopedic Surgeons, Supra. 4. Preclusion regarding claims within exclusive federal jurisdiction, 2352. A frequent problem arises when a federal suit asserts a claim that could not have been raised in an earlier state court action because it was subject to exclusive federal jurisdiction, and a party argues that the federal claim is nevertheless precluded by the judgment in the state court case. A. Rule of jurisdictional competence for claim preclusion 2353. The law of most states is that claim preclusion is not available with respect to a claim over which the court does not have subject matter jurisdiction. Restatement 2nd of Judgments 261c rationale. If the court cannot entertain the claim, it should not be able by its judgment to extinguish the claim. B. Distinguish issue preclusive effects 2354. If the state court decision of a state law claim resolves issues that are also presented by a federal claim, those determinations can be given effect in a later federal suit, asserting the federal claim, even if that claim is within exclusive federal jurisdiction. Kremer v. Chemical Construction Corp., 456 U.S. 461 1982 issue preclusion applicable to Title Roman VII employment discrimination claim, although unclear whether there is exclusive federal jurisdiction over such claims. Betcher v. Contour Laboratories, Inc., 279 U.S. 388 1929 issue preclusion from state court suit bars subsequent federal patent suit. C. Possible argument for exception to full faith and credit statute 2355. If state law indicates that a state court judgment should be given preclusive effect, even with regard to a claim within exclusive federal jurisdiction, there may be a basis for finding an exception to Section 1738 if the grounds for prohibiting state courts from adjudicating such claims support finding a partial repeal of the statute. But the Supreme Court has said that this is a relatively stringent standard for finding such a repeal, depending on an irreconcilable conflict between Section 1738 and the congressional grant of exclusive federal jurisdiction. Matsushita Electric Industrial Co. v. Epstein, 516 U.S. 367 1996.